Okay, welcome to class video 14, in which we're going to discuss the concept of patent infringement, or how the patent infringement analysis is performed. So in the last several classes, we've been talking about the substantive requirements for patentability. Now we're going to be looking at what happens when a patent owner asserts that patent against an alleged infringer and their offending product. So how does this work? Well, the Patent Act grants the authority for patent owners to bring infringement actions essentially against anyone who uses a patent claim that they own without permission. Now, important caveat, you have to actually be the patent owner. So it's either the inventor or the transferee of the patent. And you actually have to have standing to bring a patent infringement claim as well. In other words, you have to actually own the patent. You can't just have a right to use it. But if that's true, then you can assert the patent against anyone in the world who is practicing it without your permission, even if they don't know that the patent exists, right? So patent infringement is a strict liability offense. If a patent is on, if a patent exists, then it's presumed to be available to the public, and anyone practicing in that field of art has an obligation to know about the existence of that patent. And if they practice it without the permission of the patent owner, then they have the potential to be liable for patent infringement. Okay. So again, making, using, offering to sell, selling, importing, basically doing anything using the patented claims, right? There's no exceptions just for producing products. Anyone up and down the supply chain can be liable for patent infringement if they are practicing the claim without permission, or distributing products created by practicing the claim without permission. And in addition, the Patent Act provides for both direct and indirect infringement. And we'll see this in relation to other forms of intellectual property as well. But in other words, if you infringe the patent claims yourself by actually practicing them yourself, then you're an infringer. But you're also indirectly infringing if you make it possible for someone else to engage in infringing conduct, right? So if you produce something that enables someone else to infringe, right, then you can also be liable for infringement as an indirect infringer, so long as the requirements for indirect infringement are satisfied. We'll talk about that again in the context of other forms of intellectual property, but the requirements are similar, and you can kind of analogize amongst them, right? So the important thing to remember is that you don't necessarily have to be doing the practicing of the patent yourself. You can be facilitating the practicing of the patented claim, and that's still enough to create infringement liability. And that's often the case when it comes to things like methods patents, for example. You don't have to actually perform the method yourself. You can enable someone else to perform the method, and that might be infringing. Okay, so in order to determine whether or not a accused party is a direct infringer, well, what do? First, obviously, claim construction, patent construction. You do a Markman type analysis, figure out what the patent claims actually say, and what the scope of the patent actually is. And then once you've determined what the properly construed claims cover, you compare them to the accused product, right, the offending practicing product or service, and determine whether or not all of the limitations, all of the elements of the patent claim read onto that accused product, right? So everything that's claimed by the patent has to be present in the accused product in order for there to be patent infringement. And likewise, indirect infringement, basically, the question is, have you enabled or induced a third party to satisfy the direct infringement analysis, right? There still has to be a direct infringer of some kind. It's just the person who's the defendant that doesn't necessarily have to be the direct infringer. And we'll talk about why that might be appealing to patent owners, and maybe even necessary to make the patent system really viable. Okay, there are several defenses, of course. The most obvious defense is to say the patent claim doesn't read onto the accused product, right? I didn't infringe because I didn't do what the patent is claiming. If the defendant can prove that not all the limitations are present, then they're not an infringer and they won't be liable. Likewise, if they have a license, right, they purchased a right to do it, well, then obviously they're not an infringer under those circumstances either. And then finally, they can attack the validity of the patent itself. In other words, the patent office shouldn't have issued this patent in the first place. The patent is invalid and I can't be an infringer because an invalid patent doesn't provide any patent rights and therefore there's nothing left for me to infringe. Okay, well, let's look at the Nassau v. Acuity case. So Nassau owned a patent over a method of producing golf club heads. Right? Essentially, the idea was that this method was going to produce golf club heads that were more effective at hitting balls longer distances, I presume, by constructing the heads slightly differently, specifically removing material from the top of the golf club head and relocating it to the bottom and middle of the golf club head, thereby imparting more kinetic energy to the golf ball when it's hit, right? You're not normally hitting the golf ball with the top of the head, so there's no reason to have the material there. If you take it from there and put it somewhere else, it'll be the same weight, but it'll be in a more physically effective location for hitting the ball a longer distance. Okay. Well, they bring an action against Acuity for infringing their patent claims, and the district court dismisses their claims, finding that the claims don't read onto the Acuity clubs. In other words, the language of the claims isn't present in the actual products themselves, right? The things that are claimed, because they're the product doesn't embody everything that's in the language of the patent claim. Well, why not? Right? Because of how the patent claims describe what's taking place. Specifically, the patent claim says, remove the material from the top and put the material on the bottom for one of the claims. And the district court finds that doesn't read on, and likewise a finding about where the material came from, right? The district court construed it as saying none of the material could come from the face of the club, and found that had taken place in the offending product. Well, the Federal Circuit ruled partially affirmed and partially reversed, although not in a very aggressive way, the district court finding. First, it found that one of the claims about removing the material from one location and putting it in another had not been infringed. And why not? Well, it construed that claim as saying all of the material taken from one place had to be relocated to another place, but the Acuity product actually took the material away and then replaced it with something else while maintaining the same club head weight. That meant that not all of the material could be removed because the stuff it was replaced with weighed something. So a little bit less than all of that weight was relocated. That is not consistent with the patent claim, and therefore, based on the facts before the court, the patent claim didn't read onto the offending product. Now, the other question was about the removal of material from the face of the club, and the conclusion was, well, on some readings of the patent claim, that might still have been infringed. And therefore, we'll have to see, the district court will have to see, based on the evidence produced by the parties, whether or not that claim was actually infringed, with the implication that that reading of the Nassau claim might be so broad as to endanger the validity of the patent itself. So there's a little bit of a, be careful what you wish for quality to this. Nassau, while preserving the potential viability of its claim, may have cast into question the viability of the actual underlying claim. It's a patent claim itself, not just infringement claim, but underlying patent claim. Okay, and then finally, the Acuity, the defendant, pointed to the fact that Nassau referred to its patent as a method patent and said, well, they're not claiming a method of producing the club. And in fact, we didn't produce the club by taking stuff off from one place and putting it in another place at all. We just cast it all in one go. And the court rejects that out of hand. It says, look, that's not what we mean by a method claim. It's really by any method of producing it. It doesn't matter what method that happens to be. And what's more, what the patent claim is really going to is the design of the club, not the production of the club. So here, really what Nassau's claim is being construed as by the Federal Circuit is a method of designing the club, or conceptualizing the club such that it would be viable to produce such a product in its final form. So that defense is rejected on the ground. That's the wrong way to read the patent claim in question. Okay, so illustration of how the infringement analysis works. In addition, there's an important doctrine that comes into play when we don't have a situation where there's literal infringement, right? Like literally the entire patent claim reads in all of its limitations onto the accused product, but a circumstance where it's what's known as non-literal infringement, in which the claims more or less read onto the product, and as in some sort of fundamental way, the differences are immaterial between the two. And the idea here really is that if we read patents too literally, right, we only allow for claims for literal infringement, it'll mean that potential defendants can avoid infringement liability merely by making small immaterial changes to their product that don't actually change the way that the product fundamentally works. So this kind of the doctrine of equivalence was sort of born in the Supreme Court's Winans v. Denmead case, right? And it involved a patent over a railroad car that could be used for dumping loose material. And the railroad car was in the shape of the frustum of a cone, as it's called. So it's sort of like the top part of a cone pointing down. You can see an illustration in the picture here. And the defendants saw the patent, or saw the product that was being based on the patent, and they said, well, that's one way of doing it. We can think of another way. And they produced their own product that was very similar, except instead of being a cone, it had 8 sides, right? It's an octagonal shaped railroad car, but same basic principle. And they said, look, the patent doesn't read onto our product. The patent claims a cone. This isn't a cone. Therefore, we win. And the court says, no, so fast, right? A majority of the court says that's not going to fly. Changing it into an octagon rather than a cone doesn't affect the function of the product. And therefore, it's equivalent to making a product with a cone. Therefore, it's still infringing. We don't want you to be able to avoid the patent simply by making this kind of immaterial change. Now, some of the justices disagreed, and they said, look, the whole point of having patent claims in the first place is to tell the entire world what is owned by the patent owner, to tell them what they can and what they can't do. And if the patent says a cone, well, then it has to be a cone, or if it doesn't infringe. And if they wanted to claim more broadly or claim other shapes, then they dang well should have done that. And the fact that they didn't means that it shouldn't belong to them, and this product should not be infringing. Now, a lot of pushback against the doctrine of equivalence over the years, but the Supreme Court has really stuck to it, albeit with an effort to, kind of keep it limited, right? Because of course there is a real problem here of uncertainty, right? The whole point of having patent claims, of examining patents, of negotiating the language of the patent claims is in order to ensure that, these property rights that can be asserted against the entire world are actually clear about what the patent owner has and what they can legitimately assert. And we don't want to have the kind of vagueness that's introduced by the doctrine of equivalence, make it so that potential defendants just don't know what they're allowed to do and what they're not, right? So the courts try to keep the doctrine of equivalence within reason, and not allow it to sort of get outside the bounds of this kind of limited way of ensuring that essentially defendants aren't making trivial changes in order simply to avoid patents, and not in order to make meaningfully different products from the patent claims themselves.